Hi, this is Layli Miller-Muro from the Tahirih Justice Center. The Tahirih Justice Center provides free legal services on behalf of immigrant women and girls throughout the United States in its offices in Washington, D.C., Baltimore, Houston, Texas, and San Francisco. So tonight I'm going to share with you what just happened in the Ninth Circuit Court tonight, and then more interestingly what will happen next. So as many of you know, the Washington State Federal District Court issued what's called a temporary restraining order against the executive order issued by the president that imposes a so-called travel ban. Now, there were 3 executive orders altogether. This lawsuit only relates to the first one. There were 3 that all dealt with immigrants' ability to live in the United States, whether they would be deported and whether they can come in. But the decision tonight was just limited to the issues in the first executive order. So what happened was that the Washington State Federal District Court issued a temporary restraining order against the implementation of that particular executive order, which was basically to say there is a likelihood of success on the merits of this case. And so while we fully adjudicate whether or not this executive order is constitutional, I'm willing, the judge, willing to impose a temporary restraining order to temporarily restrain the implementation of the executive order. It was that decision that the government appealed to the Ninth Circuit. So to be clear, the underlying issue of whether or not this executive order is constitutional, whether it violates certain immigration statutes, none of that has been discussed yet. None of that has been fully debated, fully adjudicated, and this case does not change that. So the underlying issue of whether or not it's constitutional still has not been addressed, but the lower court had to ask the question, is there a likelihood that this case could be successful in order to implement the restraining order? And it found that it could. It's not the same thing as finding that Washington State is successful on their claims that it's unconstitutional. It's only saying they might be successful, and then he implemented this temporary restraining order. So then what the government did is it filed something called a motion to stay the temporary restraining order. It's kind of like another restraining order on top of the restraining order. It's a motion to stay or to withhold the implementation of the temporary restraining order, which itself was a mechanism meant to withhold the implementation of the executive order. So it is a little bit complicated, but it was that stay that was decided tonight by the Ninth Circuit. So I'm going to go into the decision on the Ninth Circuit, but I want to give you the bottom line, so what conclusion of what happened tonight first. And so the bottom line is that the executive order's travel ban, and I'll just leave it at that. It's way more complicated, and the phrase travel ban is not a great phrase, but it's that thing that's being debated in the press that will continue to be on hold. So for people still wondering if you're a permanent resident, if you have a student visa, any of the other immigrant or non-immigrant visas that were affected by this executive order, you can still travel. So the ban, the immigration travel ban from those 7 countries that were put in place by the executive order is still not in place. So that order from the Washington State District Court judge that said, I am going to suspend the implementation of that travel ban is still in place. So the bottom line is you can still travel because the Ninth Circuit kept it in place. But like I said before, the underlying question of whether this executive order is constitutional still has not actually been addressed. It's only the temporary restraining order, and whether that can go into play or whether that can remain is the issue. So that's the bottom line, and then the appeal on that will be to the Supreme Court. The Supreme Court will be appealed to, no doubt, by the government. What will happen then is that Justice Kennedy, because he is the Supreme Court justice assigned to the Ninth Circuit, will review this decision. So emergency motions like this are reviewed by the U.S. Supreme Court differently than full-blown decisions where they actually choose whether or not they want to hear the case. So in this emergency situation, it will be Justice Kennedy who will determine his opinion, and then he can, if he wants, bring in all justices. Most people agree that given the significance of this case, it is very likely that all 8 now, because we don't have 9 judges yet, will be brought in on this case. If they are split, if they disagree, and there's a 4-4 decision, then what holds is the Ninth Circuit decision. The precedent will revert down to the Ninth Circuit. So it's a very interesting adjudication situation. And of course, as we know, that Ninth Supreme Court nominee is currently being debated. Depending on the timing of all of this, it will likely still be an 8-judge Supreme Court. There's a chance that they'll fast track that, and then it will be a 9-judge Supreme Court, but that's yet to be seen. Okay, so those are kind of the bottom lines. Now, the decision itself was actually very interesting because it dealt with several questions. The first question was whether this is appealable at all. Now, temporary restraining orders are not usually appealable, but preliminary injunctions are. I won't put you through law school, and I won't explain the difference between a preliminary injunction and temporary restraining order. But basically what the court did is it said, yes, the judge called it a temporary restraining order, but it looks like a preliminary injunction, it walks like a preliminary injunction, and it smells like a preliminary injunction. So we're going to treat it like a preliminary injunction and allow the appeal to go forward. So if you read the decision, there's certain legal tests around what is a temporary restraining order versus a preliminary injunction. And the court basically said, we're going to treat this like a preliminary injunction because it has so many qualities of a preliminary injunction. The other big issue that was being debated was whether or not Washington State even had standing, whether it had a legal right to bring this lawsuit at all. And they made lots of arguments, like their businesses were affected, their citizens were affected, the universities were affected. And what was interesting is in this decision, it was only the fact that they put forward the pain and the suffering of the universities as a result of this executive order as a way to find that Washington State had standing. The reason for that is that there's prior court precedent that holds very clearly that public universities are an extension of the state. And so where they are harmed, the state is by extension harmed. And so Washington State had sufficient standing under that precedent. The other issue, which was very interesting legally, was the government argued that the Washington State Federal District Court didn't have, and neither did the Ninth Circuit, have any legal authority to review these executive orders at all. And in support of that argument, they said that the President of the United States has, quote, unreviewable authority to suspend any class of aliens, end quote. Aliens, by the way, is the legal term that is used to describe immigrants in the United States. Just as an aside, I want to note that it is all throughout our statutes and all throughout our laws, this reference to aliens, which is how we refer in the United States to people who are immigrants. Canada, by stark contrast, in all their legal documents, their statutes, and their court cases, refer to immigrants as newcomers. So the legal word in the United States are aliens. Canada calls them newcomers. So what they were arguing is that the President of the United States has unreviewable authority to suspend any class of aliens. The court, the Ninth Circuit, said that is not true. And what is true is that the president has a great deal of deference when it comes to these determinations, but particularly where there are issues of constitutionality or unconstitutionality alleged, as in this case, then that is the job. That is precisely the job of the federal courts, to review these kinds of decisions. So that part of this decision I found very fascinating because it was most squarely about, I think, a core principle debate that's happening right now, which is how much authority does the president have? And the court very clearly here said that where there are constitutional allegations in matters of immigration, those are clearly reviewable by the court. So then once they got through all of those legal issues, then they denied the motion to stay the temporary restraining order, which itself was a mechanism to prevent the implementation of the underlying executive order. So there are a lot of layers here between the temporary restraining order and then the motion to stay the implementation of the temporary restraining order, which was itself a mechanism to prevent the implementation of the executive order. That does make it really, really complicated. And for those who have always thought our courts were complicated, the processes seemed like having a lot of layers to them and maybe is inefficient. What is interesting about what's happening right now is that all of those layers are protective mechanisms around things like this, where many people are being affected, families are being divided, there's financial consequence, safety consequence to people being affected by this. But what is interesting legally is that none of this is really necessary, because procedurally, the president has the authority to simply write a new executive order that would be more constitutionally compliant. And he could even do that while this executive order, let's say arguably he prefers the one he originally wrote, continues to be debated through the courts. He could do that. He could obviously also very quickly, with the swiftness of his pen, revoke that executive order and just do something differently. But unless or until that happens, we're stuck in lots of court proceedings, hundreds and hundreds of lawyers. I can tell you the Tahirih Justice Center has been involved in this appeal. We, along with a number of other organizations, submitted what's called an amicus brief to make arguments around how we as an organization and how our clients are being affected by this. So the Tahirih Justice Center has weighed in. In fact, we are involved either by virtue of our drafting or strategizing or direct named involvement in a total of 5 of lawsuits around the country. And so we are very, very involved. If anyone is interested in getting more information about the Tahirih Justice Center's response to the executive orders and to see copies of our analysis or any of these legal pleadings, we have just created a web page on a web page on our website that deals with the executive orders. If you go to www.tahirih.org, TAHIRIH.org, under our newsroom, you can very quickly access this page that will have a lot more information there. So there are a lot of resources, there are a lot of lawyers, there are a lot of lawsuits, there are lots of procedures and lots of things going on with this case and still yet to happen. But strictly procedurally speaking, it would be possible for the president to simply rewrite or do a different executive order. Nevertheless, where we are right now in all of this is that pending the decision that was made today, and even what was interesting is that the government basically said in its legal arguments, even if you deny our motion, so it had a plan B for the court. It said, even if you deny our motion to stay this temporary restraining order, please limit the scope of the temporary restraining order. So the temporary restraining order, you'll remember, said all throughout the country, we're going to hold the implementation of the executive order, and we are going to restrain the implementation of the entire executive order. The government made an argument that if the court denied their motion to stay, that it limit the scope of the limitation of the implementation of the executive order. It said, only apply it to Washington State, only apply it to permanent residents. It made all these arguments. And basically the court came back and said, we're not in the business of rewriting executive orders. That's the president's job. So we're only going to review what was given to us, which I thought was also interesting. The court declined to engineer a different kind of order that may be more acceptable, maybe more limited in scope, or may be more constitutionally worded. They refrained from doing that. And they said, our job is to simply review what has been given to us. And so they declined the government's request to limit the scope of the applicability of the temporary restraining order. So where we're headed next is likely the Supreme Court, unless the president makes a choice about this particular executive order, rescinds it or rewrites it. And then when that happens, as I mentioned, we could face some really interesting tie issues at the Supreme Court, and even then, constitutionality. So issues of constitutionality or whether it's legal is still something that has to be reviewed by the federal district court. There is now a timeline in place for them to hear oral arguments and receive legal briefings on the underlying issue of whether it's constitutional. Again, none of that has been addressed through the temporary restraining order or the decision tonight. They only looked at likelihood of success on the merits, but that is not success on the merits. It's only predictive. So we have a long way to go legally before this whole thing is resolved. Thank you for watching, and I hope you have a good night. We'll try to keep you in touch as things develop.